My name is Nick Weiss. I am the founding attorney and managing attorney of MP Weiss Law with offices in South Euclid and Elyria, practicing family law, real estate, and estate planning and administration. I want to talk about common law marriage. And most importantly, does Ohio recognize common law marriage? Common law marriage is marriage without having to go through legal process. It is without a ceremony, without a license, and it requires a couple of elements. It requires that people actually cohabitate, that they hold themselves out as being married, and that can be through taking someone's name, telling other people that they're married, filing joint tax returns, any of those steps to present to the public at large and other people that they are married, that they have the intent to be married, and maybe they just missed a step, right, when they thought that they were married. And if they meet all of those elements, then they are common law married. So does Ohio recognize that? The answer is kind of. So Ohio does not recognize any common law marriage that was entered into or attempted to be entered into in Ohio after October of 1991. So if there's a common law marriage that you can prove, although it might be difficult now with how much time has gone by, that was entered into prior to October of 1991, then that marriage will be valid and have all the same protections that your typical marriage would have, with a license and an officiant, etc., etc. Ohio also has to recognize, through the full faith and credit clause of the Constitution, common law marriages that are entered into in states that recognize common law marriage. This is a minority of states now, but if there is another state that recognize common law marriage, and that had been recognized while they were there, Ohio has to honor it. Why does this matter? This matters because there are many, many, many protections, and there are many, many benefits and privileges that come with being married. Most applicable, at least in our office, is through inheritance. If someone passes away, what happens to their stuff? There are presumptions that, depending on the family makeup, that the spouse will inherit. That goes away if there's no spouse, right? And so we have to prove, in some cases, that there was an effective common law marriage, so that we can apply those estate distribution rules to that common law marriage. There are also protections for decision-making power in healthcare, right? So like there's an automatic waiver of privilege there. A spouse is entitled to talk to a doctor. A spouse is entitled to make medical decisions, to be there for their spouse if they're in trouble. No common law marriage, then that privilege does not exist. That right does not exist. So the best thing that you can do to gain those privileges, to gain those rights that you would have as ordinary spouses, is to go get married. The process now is not particularly difficult. You go down to the probate court, you get a license. Sometimes they just have marriage days down there, and you sign up, and a judge comes out, and they marry you, and the whole thing takes 10 minutes, right? It's not particularly romantic, but the judges enjoy doing it, and now you're married. If you don't want to do it, if you don't want to actually go through that process, there are estate planning steps that you can take that largely simulate all of the benefits of being married. These go to your general estate plan, right? So like naming your spouse or not spouse, as the case may be, in your will, giving them a durable power of attorney, executing a HIPAA release so that they can see your medical information, executing a healthcare power of attorney so they can make those medical decisions on your behalf. And that's just general estate planning that we might do for anyone, whether they're married or not, but is especially important for unmarried people if you want to give those rights and those privileges, particularly for inheritance, to someone. But at the end of the day, those are Band-Aids. We used to do this a lot when we had same-sex couples, right? We would enter into this kind of planning to simulate the benefits of marriage prior to same-sex marriage being lawful. We don't have to do that anymore. You can go get married, so do it. But if you're worried about it and you don't want to actually go through that process, a basic estate plan will simulate a lot of, if not all, of the benefits that you might have had if you actually got married to your spouse. If you have more questions about that, feel free to contact our office. And as a personal note, I am an officiant, and I've married many clients who have come in. Sometimes we have done it at my desk. So if you need something quick and dirty, we can do that too. One of the rights that spouses have has to do with criminal law and spousal privilege. A spouse cannot be compelled to testify against their spouse. That right doesn't exist for civil matters, but it does exist for criminal matters, and it's a powerful privilege there, right? If you are in trouble, if you have a charge against you and the prosecutor wants to call your spouse as a witness, they can refuse, right? And they can do that. If you're not married and proving common law marriage is tough here in Ohio, then you lose out on that privilege.